If you're navigating divorce or separation right now, you're probably feeling overwhelmed, uncertain, and maybe even a little lost. You're in the right place. This is the Soft Landing Divorce Podcast, where we prove that even in the midst of ending a marriage, you can move forward with dignity, clarity, and yes, peace. But here's what makes us different. Ken and Sarah are going to share solutions and strategies that the divorce industrial complex never talks about. The approaches that can save you time, money, and emotional turmoil, but that traditional divorce professionals won't tell you exist. Whether you're just starting to consider separation or you're deep in the process, our goal is simple: to help you and your children land as softly as possible on the other side. So grab your coffee, get comfortable, and let's dive in with Ken and Sarah as they reveal what the industry doesn't want you to know.
Hey everyone, welcome back. Today we're taking a deep dive into how to fast track your divorce agreement without endless paperwork, even if you have complex assets to divide. I'm Sarah, your host, and I'm thrilled to have with me Ken Maynard, a certified divorce financial analyst and accredited family mediator who's been guiding Ontario families through separation and divorce since 2010 via secure virtual mediation. Ken's soft landing divorce settlement method is a collaborative alternative to Canada's adversarial family law system, emphasizing compassion and cost effectiveness. His clients often achieve amicable, sustainable agreements in 4 meetings or fewer, avoiding courtroom conflicts. With nearly 2 decades of experience, Ken combines financial expertise and mediation skills to support families in navigating life's toughest transitions through alternative dispute resolution. Welcome, Ken.
Thanks, Sarah. It's great to be here. I'm excited to chat about this and help folks understand better options for handling divorce.
Absolutely, Ken. Let's start broadly. Many people think of the legal system as this big battle, right? Like the adversarial system where parties are pitted against each other. Can you explain what that is and some examples from Canada's perspective?
Sure thing, Sarah. The adversarial system is this conflict-based framework where opposing parties present their arguments and evidence before a neutral judge or jury. In Canada, it's common in criminal trials where prosecution and defense go at it, or in civil disputes like lawsuits, it's all about discrediting the other side to win.
Right, that makes sense. But I've heard there are drawbacks. What are some pros and cons of this system?
Exactly. On the pro side, it promotes robust advocacy, ensures transparency as everything gets scrutinized, and upholds due process by letting each side challenge the other. But cons? It creates a win-at-all-costs mentality, which can distort truth, lead to unequal access if one side has more money for lawyers, and it's often prolonged and costly.
It's fascinating, isn't it? Especially in family law, where emotions run high. How does this play out in Canada specifically?
In Canada, like other common law countries, the adversarial model is default, with parties in court trying to persuade the judge. But we're seeing a shift. Canada incorporates alternative dispute resolution, or ADR, like mediation and collaborative law, especially in family cases, to promote efficiency and satisfaction.
That sounds promising. So family law has evolved from this adversarial roots. Tell us more about that evolution.
Family law used to be all about that win-lose mentality in divorces, custody, property disputes. But now, with better understanding of family dynamics, we're moving to holistic approaches. Things like collaborative law, where parties and lawyers work together outside court, or therapeutic jurisprudence, focusing on emotional well-being.
I see. In family law, the adversarial system seems particularly tough. Why is that?
You've hit the nail on the head, Sarah. It can cause long-lasting damage, especially to children whose well-being gets sidelined in the battle. It doesn't address emotional dynamics well, escalates costs, and prolongs conflicts, leading to more stress and animosity.
So to everyone listening, Have you ever thought about how a court battle might affect your kids long term? Ken, what are some alternatives to this adversarial approach?
Great question. Alternatives include mediation, where a neutral third party helps negotiate, collaborative law, committing to out of court resolution, arbitration for binding decisions, and even restorative justice for healing. These emphasize collaboration and compromise.
Mediation sounds key. How does it help in family conflicts?
Mediation is fantastic for diffusing tensions. It promotes open dialogue, helps develop co-parenting plans, divide assets, and set custody. It's confidential, cost-effective, and empowers families to control outcomes, leading to sustainable agreements and healthier relationships.
Absolutely. And the impact on children, that's huge. Can you elaborate on how the adversarial system affects kids and families?
Children often suffer silently in these battles. Prolonged fights cause stress, anxiety, instability. Studies show long-term effects like academic issues, behavioral problems. It also drains finances, adding hardship. That's why we advocate for child-centric approaches and early alternatives.
Right, so moving to a holistic approach makes sense. What's that look like in family law?
It's about nurturing relationships, prioritizing kids' well-being, integrating mental health pros, community resources, and ADR like mediation to create tailored solutions that foster harmony.
I love the Coliseum model analogy from your work, Ken. It's like gladiators fighting in an arena. Can you explain that to our listeners?
Sure, Sarah. Imagine each side hires a gladiator, their lawyer, and they battle in the courtroom Coliseum with the judge as Caesar deciding fate. It works for strangers in accidents or contracts since they don't interact after. But for families, you're still connected, especially co-parenting. It causes irreparable damage.
Exactly. And the long-term impact, you say how you start your divorce is how you'll live post-divorce.
Yes, contentious litigation leads to repeat court trips, emotional and financial tolls. Better ways protect relationships.
So your soft landing method is a better way. Tell us about it.
The soft landing separation and divorce settlement method emphasizes collaboration, empathy. Using mediation and collaborative law, it reduces conflict, supports families, aims for fair, sustainable solutions in 4 meetings or less, often via video or in person.
That's awesome. Now, rethinking lawyering up, why seek mediation and financial guidance first?
Divorce is 90% finances and children, not just legal. Start with a mediator and CDFA for control, financial clarity, comprehensive disclosure, focused negotiations. It's cost effective, reduces animosity, holistic, and better for kids.
Can you see how that plays out in your own experience, listeners? Ken, let's touch on some FAQs. Where is the adversarial system most used?
Mostly in common law countries like Canada, US, UK, Australia, New Zealand.
And when did it originate?
In medieval England, evolving over centuries.
How's it different from inquisitorial?
Adversarial has parties presenting to a judge. Inquisitorial has the judge investigating.
Advantages?
Thorough evidence examination, fairness, equal opportunity.
How does it work in practice?
Parties present evidence and arguments to a neutral decider.
Starting family mediation or collaborative law?
Contact a mediator or trained lawyer. They'll assess and guide.
Alternatives in family law?
Mediation, collaborative law, arbitration, focusing on cooperation.
Why avoid adversarial in family law?
Reduces conflict, saves time, money, promotes amicable resolutions, especially with kids.
What is it in family law?
2 parties argue before a judge, often increasing conflict.
Now, those 7 key takeaways about the adversarial system.
It escalates conflict, involves opposing parties before a judge. CDFAs provide financial insights. Mediation reduces costs and aims for mutual solutions, offers control and clarity, reduces animosity, and takes a holistic approach, including kids' welfare.
So we've established a lot today. For our listeners, at DTSW, you offer this soft landing method to simplify divorce.
Yes, we help couples craft agreements in 4 meetings or less via video or in 6 Greater Toronto centers.
Have you ever thought about it that way, folks? Switching to alternatives could change everything.
Absolutely.
So as we wrap things up, what's a final takeaway, Ken?
Embrace alternatives like mediation for a compassionate, efficient divorce that protects your family.
And on that note, stay curious. Keep those questions coming. Until next time, keep exploring better ways to resolve conflicts. What might you do differently now that you understand exploring Canada's adversarial system and its alternatives in family law?
And that's a wrap on today's episode. Remember, the path you're on right now, it doesn't have to be as hard, as expensive, or as damaging as the divorce industry wants you to believe. You have more options than they're telling you, and more power than you realize. If today's conversation resonated with you, here's what we'd love you to do. First, subscribe to the Soft Landing Divorce podcast so you never miss these strategies that could change everything for your family. Second, leave us a review. It helps other people who desperately need this information find us. And if you know someone who's struggling through separation or divorce, please share this episode with them. Sometimes the kindest thing we can do is let someone know they're not alone and there's a better way forward. You can find all our resources, show notes, and ways to connect with us at dtsw.ca. And remember, we're not just here once a week, we're building a community of people who believe that divorce doesn't have to destroy families. Hit that subscribe button because we've got so much more to share with you in the weeks ahead. Until then, keep moving toward your soft landing. You've got this, and we've got you. That's Ken and Sarah, and they'll see you next time. Disclaimer. The information provided in this podcast is intended for general informational purposes only and does not constitute legal advice. For legal guidance specific to your situation, please consult a qualified legal professional in your jurisdiction.